Hello everyone, warm greetings to all. I hope every one of you is doing well. I, Dr. Shikha Dhiman, Assistant Professor, Department of Laws, Guru Nanak Dev University, Amritsar, will be presenting on the topic Fundamental Rights and Associated Challenges under the Constitution of India, a Feministic Perspective. Let's start with an introduction. The Indian Constitution, a living document, embodies the aspirations of its people for justice, liberty and equality. The framers of the Constitution envisioned a society where every individual, irrespective of gender, could thrive without discrimination. This vision is encapsulated in the fundamental rights enshrined in Part 3 of the Constitution, which are pivotal in the pursuit of gender justice. However, despite the constitutional guarantees, the path to achieving gender equality is fraught with challenges that require a nuanced understanding from a feministic perspective. The right to equality, stretching from Articles 14 to 18, serves as the bedrock for gender justice in India. It promises equality before the law and equal protection of laws. Yet, the lived reality of the women and marginalized genders often belies this promise. The feminist critique of the Constitution arises from the gap between the de jure equality granted by the text and the de facto inequality experienced by the women. This critique is not a denouncement of the Constitution, but a call to fulfill its transformative potential. A feminist reading of the Constitution recognizes the patriarchal structures that have historically influenced laws and societal norms. It challenges the notion that laws are gender neutral and highlights how gender biases can be entrenched in legal interpretations and enforcement. The feminist perspective seeks to reinterpret the Constitution so as to ensure that gender justice is not just an abstract concept, but a tangible reality for all. The challenges to fundamental rights in India are manifold. They range from socio-political barriers to institutional biases that impede the full realization of these rights. For instance, the judiciary, while being the guardian of fundamental rights, has at the times been conservative in its approach towards gender issues. The feminist perspective argues for a more progressive and empathetic judicial interpretation that aligns with Constitution's spirit of equality and non-discrimination. Moreover, the feminist discourse on the Constitution also extends beyond the Indian legal framework to include international legal provisions and statutes. The Universal Declaration of Human Rights, that is UDHR, and the Convention on the Elimination of All Forms of Discrimination Against Women, that is CEDAW, are international instruments that reinforce the constitutional mandate for gender equality. These global commitments remind us that the struggle for gender justice is not confined within national borders, but is a universal endeavor. Now, let's understand the definition, scope and meaning. Feminist jurisprudence is a transformative legal theory that seeks to address and rectify the inequalities and biases against women that are embedded with the legal system. It is an approach that combines legal reforms with the insights of feminist theory, aiming to understand and change the law to ensure it reflects the experiences and needs of women. At its core, feminist jurisprudence challenges the traditional legal framework that often overlooks or marginalizes women's experiences. It questions the neutrality of law and asserts that law, as it has been historically developed and practiced, often perpetuates the gender biases. Feminist legal theorists also argue that the law has been used as a tool to maintain patriarchal power structures, and thus it requires a fundamental re-evaluation to achieve true gender equality. The origins of feminist jurisprudence can be traced back to the women's rights movement of 19th and earlier 20th centuries. However, it gained significant momentum in the latter half of the 20th century as a part of the second wave feminist movement. Legal scholars like Catherine McKinnon and Martha Feynman have been instrumental in shaping the discourse around feminist jurisprudence, examining how the law impacts women's lives and advocating for legal changes that recognize and protect women's rights. One of the key tenets of feminist jurisprudence is the idea that law should not only be equal but also equitable. This means that the law must take into account the different circumstances and positions of individuals to ensure a fair outcome. For instance, while the principle of formal equality would treat everyone the same, feminist jurisprudence recognizes that women often start from a disadvantaged position due to historical and systematic discrimination. Therefore, the law must sometimes provide different treatment to achieve substantive equality. Feminist jurisprudence employs various methodologies and approaches to analyze and critique the law. It includes number 1, liberal feminism, advocates for the removal of formal barriers to equality such as discriminatory laws and practices and promotes equal opportunities for women. Next is radical feminism. It focuses on the ways in which patriarchy and male dominance are entrenched in the legal system and seeks to dismantle these power structures. Another is cultural feminism. This emphasizes the value of women's experiences and contributions, advocating for recognition of differences between men and women in the law. Postmodern feminism. It challenges the idea of universal womanhood and seeks to address the diverse experience of women, particularly those marginalized by race, class, sexuality, and other factors. Feminist jurisprudence also highlights the importance of intersectionality, recognizing that women's experiences are shaped by multiple and intersecting identities. This approach ensures that the legal system takes into account the varied and complex realities of all women, not just those who fit a certain profile. In practice, the feminist jurisprudence has led to a significant legal reforms. It has influenced the development of laws related to sexual harassment, domestic violence, reproductive rights, and workplace discrimination, among others. It has also impacted the interpretation of constitutional provisions such as right to equality to include a gender-sensitive perspective. Internationally, feminist jurisprudence has been supported by various legal instruments such as the Convention on the Elimination of All Forms of Discrimination Against Women, which provides a framework for countries to promote gender equality through their legal systems. Feminist jurisprudence is a critical and evolving field that seeks to ensure the law serves as a vehicle for gender justice. It calls for the re-examination of legal concepts, structures, and practices to create more equitable legal landscape that truly reflects and responds to the needs and rights of the women. Now, talking upon the right to equality, that is Article 14 to Article 18 of the Constitution of India, a feministic perspective. The right to equality is a fundamental right enshrined in the Constitution of India, encapsulated within Articles 14 to 18. This segment of the Constitution is a testament to the country's commitment to establishing a society where every individual irrespective of gender, can live with dignity and equal opportunity. From a feminist perspective, these articles are not just legal provisions, but these are the pillars that support the bridge leading to gender just society. Article 14, Equality before law. Article 14 guarantees equality before law and equal protection of laws within the territory of India. It is the cornerstone of the right to equality, regardless of their gender, and has access to same legal protections and is subject to same legal constraints. The feminist critique of this article often revolves around its implementation, where despite the apparent gender neutrality, women may face systematic and institutional bias that affect their equal status before law. This broad provision includes within its ambit the rights of women to be treated as equals in all spheres of life. However, the journey towards actualizing this equality has been fraught with the challenges. The societal norms and patriarchal structures have often undermined the constitutional mandate, necessitating the judicial intervention to uphold the women's rights. Next is Article 15, Prohibition of discrimination. Article 15 prohibits discrimination on the grounds of religion, race, caste, sex or place of birth. It is a significant provision from a feminist viewpoint, as it explicitly includes sex as a ground on which discrimination is not permissible. This article empowers the state to make special provisions for women and children, recognizing the need to address historical and structural disadvantages that women have faced. Article 15 Clause 1 specifically prohibits the discrimination on the grounds of religion, race, caste, sex or place of birth. Further, Article 15 Clause 3 empowers the state to make special provisions for women and children, recognizing the need to reverse the historical injustices and provide an impetus for achieving substantive equality. Next provision is the Article 16, that is equality of opportunity. Article 16 ensures equality of opportunity in matters of public employment. It mandates that there cannot be any discrimination against anyone in recruitment and conditions of employment on the grounds mentioned in Article 15. For feminists, this article is crucial in the fight against gender discrimination in the workplace and also for creating an equitable work environment. Article 17, Abolition of untouchability. While Article 17 primarily addresses the abolition of untouchability, its ethos of eradicating social discrimination resonates with feminist ideals. Feminism seeks to dismantle all forms of social hierarchies and prejudices, which include those based on gender. Article 18, Abolition of titles. Article 18 abolishes titles that create artificial distinctions among individuals. Feminists argue that societal titles and honors often reinforce gender stereotypes and contribute to the stratification that places women in subordinate positions. Now, despite these constitutional guarantees, the lived reality of many women does not reflect the equality as envisioned by the framers of the Constitution. Issues such as gender-based violence, unequal pay, lack of representation in decision-making positions, etc. continues to persist. The judiciary has played a pivotal role in addressing these challenges through its landmark judgments. Now, let us talk upon some case laws regarding the feminist jurisprudence. The interpretation of these articles has evolved through various landmark judgments that have furthered the cause of gender equality. Very important case, Air India versus Nargesh Mirza, 1981. The Supreme Court struck down regulations that discriminated against air hostesses based on gender upholding right to equality of employment opportunity. The Vishakha Guidelines 1997, laid down by the Supreme Court in the absence of a legislative framework, were a set of procedural guidelines for dealing with sexual harassment at the workplace, which later culminated in the Sexual Harassment of Women at Workplace Act 2013. Next, the Navtej Singh Johar case of 2018, where the Supreme Court decriminalized homosexuality, and it was a significant step in recognizing the rights of LGBTQ community under Article 14 and 15. In the realm of family law, the Supreme Court's judgment in Vinita Sharma versus Rakesh Sharma clarified that the daughters would have equal co-partnership rights in the Hindu undivided family property, irrespective of whether they were born before or after 2005 amendment to the Hindu Succession Act. The Constitution also addresses economic rights through Article 39, Clause D, which mandates equal pay for equal work for both men and women. While this has been a statutory right for decades, the gender pay gap remains a stark reality, indicating the need for more effective enforcement mechanisms. The directive principles of state policy further underscore the commitment to gender equality, with Article 39, Clause A, directing the state to ensure that men and women equally have the right to an adequate means of livelihood. Additionally, Article 42 directs the state to make provisions for securing just and humane conditions of work and for maternity reliefs. Now, what are the challenges and what is the way ahead? Despite these robust constitutional provisions, the challenges to achieving true equality are manifold. Social prejudices, economic dependencies, and cultural norms often result in the unequal application of these rights. The feminist movement in India continues to advocate for not just formal equality, but substantive equality, which definitely takes into account the existing inequalities and strives to rectify them. While the right to equality provides for a strong legal framework for gender justice, its true realization requires vigilant enforcement, progressive interpretation, and of course, a societal change that aligns with the feminist principles. The journey towards equality is ongoing, and the feminist perspective serves as a critical lens through which the gaps in the implementation and the potential reforms can be identified and addressed. Now, let's talk over the gender justice and the role of judiciary. The Indian judiciary has been a pivotal force in shaping the discourse on gender justice, often serving as the arbiter of rights when legislative and executive actions have been wanting. The judiciary's role in interpreting the Constitution has led to significant advancements in gender justice. Yet, the path remains fraught with systemic challenges and societal prejudices. This thing delves into the intricate relationship between gender justice and the judiciary, thereby examining the landmark judgments, the impact of feminist jurisprudence, and of course, the ongoing struggle for equality within the legal profession itself. Now, what about the gender representation in the judiciary? The representation of women in the Indian judiciary has been historically very low. As of 2021, only 8 female judges had been appointed to the Supreme Court since its inception in 1950. The High Courts fare slightly better, with women constituting approximately 11% of the total number of judges. This underrepresentation is not merely a statistic. It reflects the systematic barriers women face in the legal profession, from gender bias and harassment to challenges of the balancing work and the family lives. Now, there are many landmark judgments that relates with the feminist jurisprudence. The Indian judiciary has delivered several landmark judgments that have advanced gender justice. The Vishakha guidelines laid down by the Supreme Court in the case of Vishakha versus State of Rajasthan established the framework for preventing sexual harassment at the workplace. In the Mary Roy versus State of Kerala, the Supreme Court granted Syrian Christian women the right to seek an equal share in their father's property, challenging patriarchal traditions. Feminist jurisprudence has played a crucial role in these advancements, critiquing the laws and practices which perpetuates gender inequality, and of course advocating for legal reforms that recognize the social, economic and political equality of sexes. Now, what are the challenges within the judiciary? Despite these progressive judgments, the judiciary itself is not immune to patriarchal norms. The collegium system of selecting the judges has been criticized for reflecting gender biases. Moreover, the issue of discrimination extends beyond the court's design, affecting women lawyers and judges through everyday gender bias and workplace harassment. There are many international perspectives and the concerned legal provisions. Internationally, the judiciary's role in upholding the gender justice is recognized under various legal provisions. The Convention on the Elimination of All Forms of Discrimination Against Women, to which India is a signatory, calls for the elimination of discrimination against women in all its forms, including within the judiciary. The Beijing Declaration and the Platform for Action also emphasize the importance of women's equal participation in the judiciary. The journey towards gender justice in the Indian judiciary is ongoing. While there have been significant strides made through judicial activism and feminist legal theory, the full realization of gender equality within the legal system requires a concerned effort to dismantle the entrenched patriarchal structures. It is imperative that the judiciary continues to evolve not only through its judgments but also by reforming its own institutions to reflect the principles of gender justice as it upholds. Now, let us come to preamble and gender justice and how it upholds the ideals of equality and fraternity. The preamble to the Indian Constitution is more than an introduction to the statute book. It is a declaration of the ideals and aspirations that the nation strives to achieve. It embodies the essence of gender justice, which is not merely a legal framework but a societal goal to ensure that all genders are treated with equality and dignity. The preamble's commitment to justice, that is social, economic and political, is a foundational stone for gender justice. It envisions a society where every individual, irrespective of gender, has an equal stake in the country's social, economic and political fabric. The preamble's assurance of equality of status and opportunity further cements the constitutional commitment to creating a level playing field for all genders. Further, the equality and fraternity, that is a dual commitment. The preamble's promise of equality is not limited to the legal domain but extends to ensuring substantive equality in the society. This means that dismantling the structures of the discrimination and creating an environment where women and other marginalized genders can thrive without prejudice or bias. The mention of fraternity in the preamble is very significant as it underlines the need for a sense of brotherhood and unity that transcends gender divisions and also promotes a culture of mutual respect and support. Now, there are some case laws that upholds the gender justice. Several landmark judgments have reinforced the preamble's vision of gender justice. The Supreme Court of India, as already discussed, in the case of Vishakha versus State of Rajasthan, established the guidelines to prevent sexual harassment at the workplace, thus promoting a safe and dignified environment for women. Mary Roy versus State of Kerala, the apex court ensured the silent Christian women could inherit the property. The judgment in the Lata Singh versus State of Uttar Pradesh protected the rights of adult women to marry a person of their choice, irrespective of caste or religion. Now, the international perspective on gender justice. The Indian commitment to gender justice is in line with the international legal provisions such as the Convention on the Elimination of All Forms of Discrimination Against Women, which advocates for the abolition of laws, customs, practices that discriminate against women. India's efforts to resonate with the Sustainable Development Goals, particularly Goal 5, which aims to achieve gender equality and empower all women and girls. The preamble of the Indian Constitution is not just a textual prologue, but a living document which guides the nation towards realizing the ideals of gender justice. It is a commitment to building an inclusive society where a gender does not dictate one's opportunities or rights. The judiciary's role in interpreting and enforcing the preamble's principles have been pivotal in advancing gender justice, reflecting dynamic and the evolving nature of the constitutional law in India. Now, let's conclude the topic. The discourse on the fundamental rights and associated challenges under the Indian Constitution, a feministic perspective, brings to the light the intricate relationship between the constitutional mandate and the realities of women in India. The Indian Constitution, as it is a living document, envisages an egalitarian society where every individual, irrespective of the gender, has the opportunity to flourish. The preamble, with its ideals of justice, liberty, equality, and fraternity, sets a tone for a nation that respects and upholds the dignity of women. The right to equality, as enshrined in the Article 14 to 18, is a testament to the constitutional commitment to creating a gender-just society. However, the journey from the de jure equality to de facto equality is fraught with the challenges. Despite the constitutional guarantees, the women in India, they face systematic discrimination and are often relegated to subordinate roles. The judiciary time and again has stepped into upholding the rights of women through landmark judgments. The women's rights and constitutional provisions have been a subject of extensive debate and development. The Constitution of India, through various articles, provides a robust framework for safeguarding the rights of women. Article 15, Clause 3, empowering the state to make provisions for women, recognizing the need for affirmative action so as to combat the historical injustices. The preamble's promise of gender justice is still an ongoing commitment, which also requires constant vigilance and proactive measures. It is not just about legal equality, but also about social and economic empowerment. The state has introduced various policies and schemes aimed at improving the status of women, yet the ground realities suggest that much remains to be done. In the conclusion, while the Indian Constitution lays down a strong foundation for gender equality, the path to achieving it is still under the construction. The feminist jurisprudence, with its emphasis on equality, liberty, and dignity, provides a critical lens to examine and challenge the patriarchal structure that impede the realization of constitutional promises. It is through sustained efforts, both legal and social, that the vision of the Constitution can be fully realized, ensuring that the women not only have the rights on paper, but also in their everyday lives. Now, this journey towards gender justice is a collective one, involving the state, judiciary, civil society, and every individual. It is a journey of transforming the society, one step at a time, to reflect the constitutional ethos of equality and justice for all. Thank you everyone for your time and attention. We have discussed the concept in a short time, and I hope that the listeners, they have understood the topic. Stay safe, stay healthy. God bless you all and take care.